freedom of speech,
fundamental rights,
freedom of conscience,
academic freedom,
freedom of press,
and the right to listen.
You're listening to So to Speak, the free speech podcast, brought to you by FIRE, the Foundation for Individual Rights in Education.
Welcome back to the show, everyone. I'm really excited about what we're going to be talking about today because we're going to be talking about a new FIRE book. FIRE's put out a number of books in our short 17-year history, and we're actually founded after the writing of a book. Alan Charles Kors, he's a professor of the Enlightenment at the University of Pennsylvania, and Harvey Silverglate, he's a civil liberties attorney based in the Boston area. In 1998, they wrote The Shadow University, The Betrayal of Liberty on America's Campuses. It's about censorship on campus. It's about due process violations on campus, civil liberties violations on campus. And after they wrote the book, it got a lot of press attention, and they received a lot of pleas for help from student and faculty members who had nowhere else to turn. And unfortunately, Alan had a full-time job, Harvey had a full-time job, so they didn't have the bandwidth to respond to all these requests or a vehicle to respond to all these requests. So they founded FIRE and co-founded FIRE in 1999, and we've been at it. We've been responding to these requests, trying to educate student and faculty members about their rights for 17 years. And during that time, part of that educational process is writing books. So in the mid-2000s, we put out our guides to student rights on campus. And if you're a student or faculty member, I really encourage you to check these out. They're on the publications page of FIRE's website at thefire.org. We're trying to update them. We're in the process of updating them right now. We've updated our free speech guide and our due process guide to incorporate new case law about student rights on campus. So we put those books out in the mid-2000s. And in 2012, we put out Unlearning Liberty, Campus Censorship, and the End of American Debate. It's written by FIRE President and CEO Greg Lukianoff. It's about his decade plus on the front lines fighting censorship on campus. And then 2 years later, in 2014, he put out another book, Freedom from Speech. And it's about the newer trends that he'd seen involving campus censorship since he put out Unlearning Liberty in 2012. These student-led drives for censorship, disinvitations of invited speakers to campus, requests for disinvitations of invited speakers to campus, microaggression policing, demands of professors to incorporate trigger warnings into their teaching. So all those books, The Shadow University, our guides to student rights on campus, Unlearning Liberty, Freedom from Speech, they're all available on Amazon. They're all available there's more information about them on FIRE's publication page on our website. But today we're going to be talking about Twisting Title IX, which is a short broadside written by FIRE Executive Director Robert Shibley about the history and abuses that FIRE's seen of Title IX on college campuses. The book comes out on Tuesday, September 27th. It's available on Amazon for pre-order right now. Robert's on the show with us today. Robert, thanks for joining us.
Thanks for having me.
So, Twisting Title IX. Before we jump into the topic of the book and the details of it, what is Title IX?
Well, Title IX is the federal law that was passed in 1972 that's intended to eliminate sex discrimination in federally funded educational programs. And when it comes to the college arena, that actually includes, and a lot of people don't realize this, both all public schools and the vast majority of private schools. And that's because it applies if your school takes a single Stafford loan or Pell Grant or any kind of research grant that comes from the federal government, then Title IX applies. So you may be going to a fairly religious school or a school that's very small. Odds are very good that Title IX still applies on your campus.
Okay. And there's something like only at 5 or 6 schools that don't take any federal funding whatsoever.
That's right. There's no official list. We know of about 5 or 6. I'll bet there are a few more. There are about 4,000 colleges and universities, four-year college and universities in the United States. So perhaps there's some more that are out there, but there are very, very few.
Okay. Well, Title IX, the way you described it, seems safe enough. Seems like there's probably not much to be concerned with there, but your book argues that there is. Why is FIRE concerned about Title IX?
Well, unfortunately, Title IX has really become unmoored from its original intention to work on eliminating sex discrimination in many circumstances in colleges and universities. and federally funded educational programs. It's interesting. Title IX is actually the active part of it is only about 39 words, and the rest of Title IX, there are hundreds more words of it, but it's all the exceptions, and those are exceptions for organizations like fraternities and sororities, for boys state and girls state, and scouting programs. There's even an exception in there for beauty contests. Colleges are allowed to have those. So Title IX was passed to eliminate sex discrimination in these programs, and that's when you would have colleges that were funded by federal money and would say only admit men or only admit women, and have a policies that even if they would not only admit men or women, but other ones that made women not able to be part of different programs. So Title IX, eliminated that, and actually did a very effective job of that. I think most prominently, this happened in the area of athletics.
Sports.
It was actually, in terms of legal attempts to end discrimination, pretty fast and pretty effective. The problem is that it's also been seized on by, unfortunately, the federal government now to start to limit the rights of students to both due process on college campuses and, of course, FIRE's core concern, which is freedom of speech.
Was there any debate when they were passing Title IX about these free speech concerns, which we'll get into in a second? What was the debate like?
Well, the debate seemed to be, and it's surprising actually how little it seems like there is out there. When I was doing research for the book, I looked in the archives of the New York Times and Washington Post, figuring they'd be the most likely to really cover the dispute there. And there was actually very little in Title IX, and what there was seemed to be surrounding the issue of athletics. I think most people understood what it was going to do in terms of academic programs, and it didn't seem like there was a lot of resistance to that. I think the concern was about athletics, and of course, up until the last few years, really almost all of the turmoil or disagreement around Title IX had to do with its effect on college athletics.
Yeah, so let's get in a little bit to how it's expanded, or at least the debate surrounding Title IX has expanded beyond college athletics. And for you, at least the story you tell in this book, it goes back to the 1980s and a certain feminist scholar, Catherine McKinnon. Can you talk a little bit about that?
That's right. It actually goes back a little bit further than that. It goes back to a strategy that was put together by Catherine McKinnon as a recently graduated and probably also partially while she was in law school at Yale University. A very early case called Alexander versus Yale was really the first legal attempt to expand Title IX from what people generally thought of as being its purpose. And Catherine McKinnon had the idea, and I'm sure others worked with her, but she's really, I guess, the leading figure on this and has been for a long time. She had the idea that Title IX could be used to also address the problem of sexual harassment on campus. And so in Alexander v. Yale, I believe there were 6 or 7 plaintiffs that sued Yale University with various complaints about various kinds of sexual harassment. All but one of the complaints were actually dismissed before really the court got going on considering them. And the final one, the court didn't actually find enough evidence to suggest that it happened. But the court did, in that case, make the determination, which is what they were looking for, that yes, sexual harassment could be treated as a form of discrimination that would be prevented under Title IX. So that was 1977.
But isn't sexual harassment already illegal? Why do you need to bring it within the fold of Title IX?
Well, sexual harassment at the time certain forms of sexual harassment are illegal because they involve other kinds of behavior. For instance, if you are sexually harassing someone in a way that is groping them or touching their genitalia in some way, that's likely to be some form of battery or sexual battery. So it would be illegal for that reason. But the idea of sexual harassment is kind of a freestanding legal problem, particularly in employment, which is where it happened first, was really only came in the 1980s, and as we know it, it really came in a case called Meritor v. Vinson, and that established the idea of hostile environment sexual harassment. So that's a kind of sexual harassment that actually there doesn't have to be intent behind it. It can just be based on an environment that is seen as offensive or hostile to either men or women, but generally it applies. It's been applied with regard to women. So you could have a situation where your workplace, even though nobody was actively trying to harass you, let's say they were hanging up centerfolds all over the place. Even if that wasn't targeted at any woman, and there wasn't an intent to make people uncomfortable, the fact that that's likely to make people uncomfortable, in 1986 was ratified by the Supreme Court as a reason to find that sexual harassment was occurring. So that happened in the employment context first, and soon afterwards it followed in the context of Title IX, which is really only has to do with education, does not have to do with employment.
Gotcha. So where did it go after this? It was 1986 case. Did the scholars like Catherine McKinnon go further in trying to get it applied to campus? Where do the speech concerns come in? Because this hostile environment harassment, quid pro quo harassment, these are things that people, at least today, after 1986, acknowledge are forms of sexual harassment. How do they become problematic from a civil libertarian standpoint?
Right. Well, the reason they've become problematic from that civil libertarian standpoint, I guess in the earliest days, and even in the earliest days of FIRE, FIRE started in 1999. And at that time, and I think this is still true today, most speech codes that you would see on college campuses were couched in the terms of harassment. So they would say that saying certain things was a form of harassment, and that Title IX obviously prohibited harassment, and therefore, since these colleges said that this speech was harassment, well, they had to prevent it. And so that's been one of the oldest fights that FIRE is actually engaged in, is these abuses of harassment law. And those regulations are in there because of Title IX. Now, would they be there without Title IX? Yeah, I think it's probably likely that even if Title IX didn't happen, that universities would have harassment laws. But certainly Title IX, gives them that federal requirement to do so. The real explosion in the problem didn't actually come until 2011, where we got the first inkling that the U.S. Department of Education's Office for Civil Rights, and they are the folks who enforce Title IX and several other civil rights statutes, we're going to start using some fairly sketchy ways of making regulations without following the usual rules in order to impair first due process on campus, and then shortly thereafter in 2013 freedom of speech.
Yeah. Before we get there, what is the proper definition of sexual harassment on campus, at least in the peer-to-peer environment, the student-to-student environment? Because campuses will write these speech codes, these anti-sexual harassment or anti-harassment codes. And just because you're calling something harassment doesn't mean it's harassment from a legal definition. Just because, for example, as a comparison, I call something incitement doesn't mean that it's actually incitement from a legal standpoint. So what's the actual definition that colleges and universities should be using when they're talking about harassment or sexual harassment on campus?
Well, FIRE's position, and I know schools often disagree with us on this, but I think it's the definition that has the most legal merit, comes from the Supreme Court. In a case, 1999 case, Davis versus Monroe County Board of Education, which, believe it or not, is a really horrendous sexual harassment case that happened between two fifth graders, of all places. But the court came up with a standard for peer-on-peer harassment in the educational context that says that if a school is going to be held responsible for violating Title IX, they have to be deliberately indifferent to sexual harassment of which they have actual knowledge, and that's so severe, pervasive, and objectively offensive that it can be said to deprive the victims of access to the educational opportunities or benefits provided by the school. And that sort of includes a couple of other requirements, which is that the harassment be discriminatory. In other words, just harassment based on hair color or something like that is not prevented by Title IX, and that there be some manner of targeting, that it not just be totally diffuse, that somebody actually has to be targeted by the harassment. And the reason the Supreme Court came up with a different standard for schools than it did for the workplace is because frankly, students aren't employees. I mean, they're closer, if anything, to something like a customer. And schools don't have and shouldn't have the same control over what students say and do that employers have over what their employees say and do at work, for a variety of reasons that are maybe outside the scope. But either way, the Supreme Court put together that pretty protective, speech protective definition of sexual harassment, and we think that's the one that schools should be using, but unfortunately they are not.
And are they not using, well, before 2011, what was the federal government telling schools to use as a definition of sexual harassment?
Well, it's pretty confusing. After Davis, the Office for Civil Rights, in some 2001 guidance that they issued, came up with a definition that, instead of using severe, persistent, and pervasive, basically said severe or persistent. And I think that would also count pervasive. And lawyers know, and I think people who are thinking about it know, that and or are not the same thing. But OCR has actually stood by this idea that in this case, they mean the same thing. They say that is actually in accord with the Davis definition. It's a really strange argument to make, but it's one they've been making for 15 or 16 years, and it's hard to take it seriously as an argument. It makes much more sense as, unfortunately, a way that the government is trying to justify using a definition that they know will result in greater speech suppression, while still arguing that it is consonant with what the Supreme Court is demanding.
Yeah, that's strange that they would argue that that's consistent with the Davis standard, when to actually make it consistent with the Davis standard, all you need to do is change a word.
Yeah, I mean, you might have to do a bit more than that, but I mean, it's not a lot more. I mean, it really is, mostly an and or situation, but it makes a difference, and schools know that. Schools try to follow OCR's advice. FIRE has been, spending years and years trying to get schools to understand that's actually not what the law requires. OCR, while it does have, the power of regulation, they're not the ones who, they don't trump the court. They don't. And they certainly don't trump Congress. And so that's been sort of a constant battle to try to get schools to understand that, even if OCR says you should be applying it in a certain way, if it's not consonant with what the Supreme Court says the Constitution requires, that's still not okay. There's not a safe harbor there. Schools have a higher duty to the Constitution than they do to, whatever bureaucrats happen to be in power at OCR at the time.
Well, are students suing schools, and are courts applying the Davis standard in determining, who's right in those cases?
Well, in some cases they are. The Davis standard is a standard that deals with Title IX specifically. So when students sue schools, when students have a Title IX claim against schools, it has to be they can't so easily sue over a standard like that. The way Title IX applies to students is, are they being discriminated against? So often when you see student Title IX suits, really the fundamental claim they have to make is that they are treating men and women differently. And if they aren't able to make that claim, then the court, generally doesn't let it go forward. So it applies in different ways, and there's really no way to make it a whole ton less confusing. But the upshot is that universities know or should know that the Davis standard is the guiding standard on this. And unfortunately, if anything, OCR is moving them further and further from that.
Are schools more afraid of the Office for Civil Rights, and when we refer to OCR, referring to the Office for Civil Rights, the Department of Education, do you get the impression that schools are more afraid of OCR than they are of any potential litigation?
Oh, absolutely. I get that sense. And I think
they're following OCR's definition
Oh,
guidance?
absolutely. And the reason is very simple: is that OCR is the agency that has the ability to go to the Department of Justice and ask them, to go through the proceedings to cut off federal funding to his school. And at most schools, that would be a death sentence because they have a huge number of students. Obviously, we know tuition is high. College costs, people are always concerned about it. Loans are really the only way many people can go, loans and grants. And so if your students can't get loans and grants, then you will very quickly cease to be a going concern.
Yeah.
So it really is a death penalty kind of situation for schools, whereas a lawsuit is, almost certainly not going to be a death penalty for most schools. So that is very terrifying to schools, and administrators generally won't go on the record about this for very good reason, but that's certainly something that many of us at Fire have had discussions with administrators who tell us that they are afraid of OCR and that they're very worried that if they don't follow what they think OCR wants, that they'll be the next to be investigated and they could potentially face this effective death sentence. I think it is worth saying there, though, that OCR has actually never tried to go that far. They've used the threat very effectively for decades, but every school has ultimately settled with the university rather than fighting it out in court. And so that's never actually happened. And so we don't know how easy or hard that might actually be.
And do you think they've never gone that far, and this is just me asking for your personal opinion, because they're afraid that if they do go that far, that their legal authority to enforce Title IX in this way will be challenged in court because the schools will have no other choice but to do so?
Yeah, I think they do have the legal authority. It was given to them. I think the question is they're going to have to defend all of the decisions they made up to that point.
Yeah.
So they're going to have to, the court would actually have finally a way to look at all the things OCR has been doing with regard to that school and say how much of this is actually required by the various laws like Title IX that you folks are supposed to be enforcing. And I think OCR would rather not find out the answer to that. And certainly a school would finally, with its back against the wall, have an incentive to put up the best possible case. You can only imagine, politically speaking, and OCR is a part of the problem with OCR is it is a political agency. I mean, the assistant secretary is appointed by the president. They're a political appointee. And so, they're not doing the same job as the courts, even though they sort of seem like a fair referee. They're not. They have a political agenda. That's just the nature of, how these executive branch offices work. Yeah. And so, they have an agenda they want to push forward. And so they are not neutral when it comes to this stuff. And they also, I think, understand, let's say that, finally, a huge university, let's say Ohio State or something, they decided they were going to try to cut Ohio State off and kill it. Can you imagine the uproar if they effectively shut down Ohio State? Yeah. I mean, that would be such a giant political disaster that it's very likely that they would never try to do that. So it really is kind of like a game of chicken between OCR and the schools, who wants to go the furthest. I suspect that shutting down Ohio State would not be tolerated. I can assure you that, all of the congressmen and senators from Ohio would be extremely angry about it. And that would not be a fun time for the bureaucrats who run OCR.
Yeah. Nevertheless, OCR is investigating something like 200 schools right now for
I think it might be upwards of 300 now.
Yeah. Especially in the last couple of years, the number of investigations has gone up.
It's skyrocketed since I think around 2014.
Yeah. So 1972, you get this law. It's mostly applied. It's like a 39-word law, as you said, mostly understood to apply to college athletics and schools that are only allowing men, only allowing women, if I'm understanding that correctly, but then expands into forms of sex discrimination that could have some implications for speech. And in the 90s and early to late 2000s, you see a lot of schools adopting anti-harassment, anti-sexual harassment codes that involve verbal conduct, which, of course, means speech, that don't meet a Davis standard or that are very broad and very vague and allow administrators to go after protected speech. bring us up to today, Robert, which you mentioned 2011, but there was also something that happened in 2000. Well, what happened in 2011, very briefly, I know what happened in 2011, mostly deals with due process, but for this
That's
podcast,
right.
we're mostly interested in the speech angle. What happened after that in 2013 as well?
Right. Well, in 2011, OCR issued in April. They issued what they call a dear colleague letter, because it begins it's dear colleague, comma, and then they say what they're going to say. That made a whole bunch of statements about how you had to obey Title IX, and with a couple of new ones. The most prominent being that from now on, when you were adjudicating sexual assault or sexual misconduct of any kind, so including harassment on campus, schools were going to be forced to use the preponderance of the evidence standard to do that. That's a 50.01% likelihood standard. And that differs, wildly from, for instance, the one most people are used to, the beyond a reasonable doubt standard, which is like a 98 to 99% certainty standard. This came as a real surprise to a lot of schools, and the reason it came as a real surprise is because regulations like that, and that was effectively a regulation, although OCR is arguing that it's not, have to go through a procedure called notice and comment. And this is where it gets in the weeds, but it is important. There's a law, that came after the New Deal era called the Administrative Procedure Act that basically says if an executive branch agency is going to effectively change the requirements of a law, they have to at least give notice of what they're planning to do and give all the stakeholders a chance to comment on it. And OCR did not do that in this place. So it came as a surprise. A lot of schools were not using preponderance of the evidence. They were using other standards, either beyond a reasonable doubt or more commonly a clear and convincing standard, kind of an 80 to 85% certainty standard. And all of a sudden they were told, well, actually, no, Title IX requires using preponderance. And my book goes through a few people. It actually opens with the example of a student who really got caught up in that when he was basically put on trial by his campus, Stanford, for sexual misconduct. So that was kind of the warning that OCR was starting to go beyond its bounds. And then in
Hold on. I want to cut you off a little bit. So the concerns from a civil libertarian standpoint is that you're setting up a system for adjudicating sexual assault, sexual misconduct cases on campus that lowers the standard of evidence, that provides for the opportunity for double jeopardy, the right for the accused.
That's right. That was another part of it.
And the accuser to appeal a verdict. Rights in some cases for the accuser to not have to confront the accused, right?
Yeah, it sort of warned schools against, although it didn't flatly ban cross-examination, which is a real problem when credibility is at issue. Cross-examination is the traditional way we deal with that,
especially in these hearsay cases.
And these are literally, in some cases, he said, she said cases. Cross-examination is very important, and yet OCR said, well, actually, you should watch out for that and maybe think about getting rid of that.
Yeah, and there are a number of other, downstream effects,
right,
for concerns over due process. But you said that, I think the key thing that you said earlier is that OCR said that this isn't a new regulation.
That's right.
Why are they saying that? Because I think it points to what we were talking about earlier with the foundation of the 1972 Title IX law. The idea being that they're just reinterpreting it, but their reinterpretation is news to us.
Yeah, and that's exactly the problem, and that's why we have these notice and comment provisions that they ignored. I think the reason that they did it through a dear colleague letter rather than a normal notice and comment regulation, which, by the way, they would have been completely free to do. I mean, they are the rulemaking agency. They could have said, hey, we're planning to require preponderance. We're giving you notice, all the stakeholders, and that would include every university, probably faculty and students, and also civil libertarians like FIRE would have been able to make arguments for or against the new regulation. The only conclusion I can come to is they thought that that wouldn't work. that there would be too much resistance to that requirement, and that they wouldn't be able to, push it through. And so instead, it came out as a surprise. And that's where it really becomes a rule of law issue as well, because frankly, nobody elected OCR to change the law.
Yeah.
We have decided through the Administrative Procedure Act, Congress gave administrative agencies the power to effectively change some requirements of the law, basically where they can find ambiguities to interpret. And the ambiguity here would be like, what constitutes discrimination? What's the nitty gritty? What are all the little details that go into trying to ensure that something is non-discriminatory? But they said the cost of that is that you have to run it by people first, and that's what OCR seems to have been very allergic to doing.
Yeah. Well, Fire's fighting back against that 2011 Dear Colleague letter through the sponsoring of a lawsuit. Again, this isn't the free speech issue, but do you want to tell us just very briefly how we're doing that?
Sure. We have two plaintiffs in that lawsuit that is being sponsored and funded by Fire. One is a John Doe plaintiff who graduated eventually from the University of Virginia Law School after being accused and going through a campus sort of kangaroo court on, this sexual misconduct charge. What makes his case perfect to challenge the interpretation that OCR is effectively using as law is that it was very clear from the judges, and I say judge because the person who wrote the opinion was actually a retired Supreme Court justice from Pennsylvania that they had hired to do this, made it very clear that she was only finding him responsible for sexual misconduct because of the preponderance of the evidence standard, and that because it was a low standard. So that's one of the plaintiffs. The other one
that's helpful because that means he has standing. It means,
well, we hope that means he has standing. The government is arguing, and as we anticipated, that he doesn't have standing for a variety of sort of complicated reasons. But it's basically a rule of thumb. Whenever you sue the government, the first thing they're going to argue, no matter what, is that you have no right to sue the government. So, and often that's very successful. So I mean, we obviously think we have the better of the argument there. We think we have a plaintiff who's as well situated as anybody. But it's in many ways it's up to the judge. And the government gets a lot of deference for what it's doing, for what it does. So, nothing is a sure thing in litigation. But, if anybody has standing, it's probably, if any student has standing, it's probably John Doe. The other group that is signed on is the only university in America, and we talked to a number of them, who was willing to come forward and actually challenge the regulation as a regulated entity, and that's Oklahoma Wesleyan University, a small religious college out in Oklahoma, who simply objects to these new regulations being passed without notice and comment. They would have liked to have commented on them, and they are opposed to them, and so would like to challenge that. And the government is also arguing they don't have standing for a variety of pretty esoteric reasons, but we're hopeful that we will get past the standing phase. I think we have a very good case there, and get to the merits of the case.
Yeah, and we'll try and keep readers at thefire.org updated on that. But this is a free speech podcast. Bring us up to 2013, Robert. The Department of Education used a different tool in this case to chill speech on campus.
Yeah, and they've done it fairly effectively. 2013 brought what's called the blueprint, and it's actually something they called it, the blueprint. It was in a settlement with the University of Montana, which was going through a really horrendous, ugly sexual misconduct scandal with its football team, and was really not in much of a position to argue with OCR given what had happened. OCR laid out, they said, well, this settlement is going to be a blueprint for colleges and universities across the nation to handle sexual misconduct on campus. And what's important about this is OCR went ahead and actually redefined the term of sexual harassment. They said that sexual harassment is any unwelcome conduct of a sexual nature, and that includes verbal conduct, and that's the entirety of the definition. If it's that, it's sexual harassment. Now, they did go, further with, some prompting from Fire later, and then they've they've mixed up that message a little bit by saying, well, you don't have to punish it, but you do have to define it as sexual harassment if it reaches that level. We don't think there's any basis in law for that. I suspect OCR probably also knows that, given that, once again, they did not try to do a notice and comment regulation. Instead, they basically said in this settlement with Montana, this is how we're treating everybody from now on. This is what we expect from you.
And they're saying that this is a requirement of Title IX?
Well, they didn't come out right out and say that, but that is the implication of it.
Yeah, well, if sexual harassment is a form of sex discrimination, it's prohibited by Title IX.
Exactly. And for OCR to have any power over something, it has to have something to do with one of the statutes that they enforce. So OCR has no power to impair your free speech or really do anything else unless they can construe it as a violation of Title IX. What they did by defining sexual harassment as any unwelcome conduct of sexual nature, including verbal conduct. And to be clear, that means a dirty joke that somebody doesn't want to hear.
That means asking someone out on a date.
Asking someone on a date who doesn't want to go. It could mean, somebody's watching, a film with nudity in it and you walk by. Anything like that could theoretically be that. It's a huge amount of conduct that or speech that people engage in all the time. If that's all sexual harassment, well, then guess what? OCR, thanks to Title IX or its interpretation of Title IX, now has power to regulate it.
Yeah.
Even if they have to admit for constitutional reasons that they don't necessarily have to punish it, they are able to say, well, this is now your problem. So somebody tells a dirty joke, they repeat Amy Schumer or Chris Rock. Somebody doesn't like it. Well, guess what, university? This is now your problem. You got to deal with it.
Yeah, and I think it's important I don't think we need to do this for our listeners, but we have seen administrators say this. Title IX does not trump the Constitution.
Yeah,
right?
No, I mean, I wish I could, maybe I should wear a T-shirt or a hat or something that says that whenever I go to campus. But, the Constitution, you cannot trump that if you are a college campus. And so regardless of what OCR seems to be saying about what sexual harassment is, that's not necessarily up to them. And, just automatic deference to them, while it seems like the least risky thing to do, can also be the morally and legally wrong thing to do.
Yeah. And we're seeing since 2013, and we saw this, as I mentioned, and as you mentioned before, we saw these overbroad and vague harassment codes throughout the 80s, 90s, and 2000s. But we've really seen the paranoia over enforcing OCR's interpretation of Title IX hit a new level in recent years. And you talk about a couple of stories in your broadside, Twisting Title IX, particularly the story of Laura Kipnis. And then I also want you to talk about the story, sort of bizarre story at Oregon.
Yeah, well, these are two, and I'll try to be as brief as I can. But Laura Kipnis made the mistake of writing an op-ed or a column for the Chronicle of Higher Education about Title IX and sort of criticizing Northwestern University's interpretation of it, after which she was charged with violating Title IX by simply writing that column, because the idea was that somehow it was discriminatory against folks who might want to make Title IX arguments, things along those lines. It was not a very coherent argument they were making against her, but it shows, just how dangerous it's become, because Northwestern snapped into action. These students made a complaint against her. Northwestern hired some out-of-town attorneys to come in. They investigated her for more than 2 months, various Skype things, I think maybe a little bit in person, sort of investigating everything. When her support, she was allowed a support person during this process. When he went to the faculty senate and said he thought this was wrong, they actually banned him from being a support person and hit him with a Title IX charge as well. And eventually the only way that this ended was she got fed up and wrote a follow-up column in the Chronicle of Higher Education called My Title IX Inquisition, and a day or two later all of the charges were dropped against her.
Well, they tried to put a gag order on her. Right?
They did. They had tried to gag her at one point. Obviously, they were trying to gag her support person. So, all in the name of sort of not retaliating. So, really, I mean, it was a Rube Goldberg scheme that was put together. And really, whose interest was being served besides the university.
Oh, yeah.
In that case, I mean, one has to ask. I mean, certainly, the measures they took might, reduce the embarrassment to Northwestern, but I don't, see who else was helped by this.
Yeah, and this is a scholar
Yeah.
writing about a timely topic that has to deal with sex, and who gets investigated under Title IX because that discussion maybe offended some other students. They thought was discriminatory.
Yeah, part of the thing is that because there is so little, respect for due process or just basic fairness in these, she wasn't actually clear, and I think to this day is not really 100% clear exactly what she's supposed to have done wrong. Like, what about what she did was wrong? That was not something that was shared with her.
Yeah. Well, as you were saying earlier with the blueprint over at the University of Montana, even if this is constitutionally protected speech, if the speech, happens to fall within that very broad definition of unwelcome verbal conduct of a sexual nature, and I mean her speech in this case was of a sexual nature. Even the the investigation itself is the punishment, even if the university can't, quote unquote, punish it.
Right. And that's relying on the university to understand that it can't punish it, which frankly OCR knows and Fire knows that they are not going to do. These investigations are not generally undertaken by attorneys who are, really up on the First Amendment. These are done by student affairs administrators, the fact finders if it comes to a trial. They're, students and faculty. This isn't, profession. This is not Floyd Abrams, doing or Eugene Volokh doing a constitutional analysis. This is universities seeing that their the expression of that student is now to be deemed sexual harassment, and then they're in the position of potentially telling the person complaining about it that yes, this person is a sexual harasser, and no, we're not going to do anything about it, which is politically completely ridiculous.
Yeah.
It's absurd to expect they're going to do that. And what they're relying on is that when Americans hear sexual harassment, they think something serious. They don't think a dirty joke, like overheard a dirty joke. They think, groping or something along those lines, or these quid pro quo thing where, I'll give you a better grade if you have sex with me or something along those lines. So the OCR knows what it's doing there, and it really is quite a cynical ploy. And I wish I had more, optimism about what they're trying to do here, but I don't.
Yeah, and they're encouraging colleges to be super risk adverse. I mean, you talk about the case at Oregon where...
Yeah, and this is a great example. It's a good segue into it. So to show you how far this goes, this student who in the book I call her Sarah Emerson, that's not her real name. She was exam week, first night of exam week. She sees some folks outside her window, a couple, man and woman, and she yells down at the woman out the window, "I hit it first." Meaning, and I've had to explain this to several people, that's the implication there is that she had already had sex with this guy.
Yeah, it's a stupid sophomoric joke that 19-year-olds make.
Yes, exactly. So this should not be a federal case, but it was soon gonna get close to becoming one, right? So this couple did not think that was funny. They stormed into the dorm, demanded to see the RA, figured out whose window it was, went up there. Demanded an apology from her, which they got. She didn't know the couple. She was just fooling around and thought that was over. But a few days later, she got hit with 5 conduct charges for including, of course, sexual harassment for yelling that joke out the window. So, sometimes people say, well, universities wouldn't abuse this or they wouldn't go so far. They know that dirty jokes aren't what OCR means. No, that is not in fact the case. If somebody complains and it fits into that rule, they are likely going to enforce it.
Yeah. Well, Fire's fighting back against this one in the same way we're fighting back against the 2011 letter. We've got a plan to push back on the 2013 resolution agreement with the University of Montana that the Department of Education actually doubled down on, or the Department of Justice actually doubled down
together.
On.
Yeah, they worked together on this. Yeah, and in a recent letter to the University of New Mexico, they made the same. They used the very same language. So the way we're taking this on is actually in a little bit different way. Rather than suing the Department of Education or Justice, this is in a case against Louisiana State University, which used substantially identical language. I think there might be very slight differences in the language, but basically the exact same language in order to strip of tenure and fire a tenured female education professor for, basically using profanity and making some jokes in the course of teaching classes to grad students. Yeah. And they when challenged on this, they cited that they had to do this because of the Department of Education and what they were expecting to be considered sexual harassment. So that case is in litigation right now. And, the wheels of justice are cranking forward slowly as usual. But that case is against LSU. And if Teresa Buchanan, again, in this lawsuit sponsored by Fire, if she is victorious, that will send a message to everybody, but most hopefully to Departments of Education and Justice, that language is not actually constitutional. And I'm very optimistic about that too, because I think it's quite obvious that a lot of protected speech is taken in by verbal conduct of a sexual nature. It's ridiculous to assume the government controls all of that speech.
Yeah. Well, what's next, Robert? What's next in this fight to preserve what we think should probably be the original intention of Title IX, which is to not go after constitutionally protected speech and limit due process and fundamental fairness on campus? Well, besides these two lawsuits,
well, obviously, everybody should buy my broadside, available September 27th on Amazon.com. But aside from that, I think ultimately the best solution to this would be legislation from Congress that would rein in OCR's power and their interpretations here. It's hard to get anything through Congress, obviously. But it's come to the point where OCR is really usurping the power of Congress. They are defining things that are really Congress's job to define, and their answers, when pulled in front of various congressional committees, because this hasn't gone unnoticed, have really been quite disappointing and I think unconvincing. So we're hopeful that in the next few years Congress will actually act to whether it be define enshrine in written law the law that is already out there in Davis, I should say, codify into law. The Davis standard would be a good choice, maybe reining in some of OCR's power to do these things or define things correctly. The fact that OCR hasn't gone to Congress and gone to allies in Congress and tried to get those things passed into law, which would give them the total imprimatur and a legitimate reason to do these things, and the fact that it hasn't even gone through notice and comment, where really, they have to get comments from people, but they're free to ignore them as long as they explain why. Mm-hmm. The fact they haven't done that suggests pretty strongly that they don't think they could, and they don't think it's popular, and they don't think people are going to see it as right.
Yeah.
And so, I'm hopeful and that, with Fire's help, Congress can get to a point where they take some of that power back from OCR or simply tell OCR, this is how we intend this to be done. That you have gone outside your bounds. This isn't what Congress intended, and you need to get back to actually enforcing civil rights rather than infringing on them.
Yeah. Well, in the meantime, I'm sure we'll see more of these Title IX abuse stories popping up. But Robert, I want to keep you around. Remind everyone, Robert's book, Twisting Title IX, comes out on September 27th. It's available on Amazon right now for pre-order. The week of September 27th, we're going to have a special Title IX blog series on our website, thefire.org. So I encourage everyone to head over there if they're looking for more information. So I want to try something different with today's show. We've been asking listeners to call in questions for the past couple of episodes, and I want to play one of those questions today for Robert and I to respond to. It comes from David in Florida and involves a very important free speech concept, the idea of anonymous speech. So, Aaron, can you roll the tape?
Hi, my name is David. I'm calling from Florida. My question relates to the relationship of anonymity to free speech. Recently, the University of Northern Kentucky University, rather, there was an issue regarding a poster that went up, basically posted anonymously and for a group that didn't exist, but it posited an idea against some orientation activities that were happening during that week. And I'm wondering if Fire has an idea or thoughts on the relationship between free speech and anonymous speech. Similarly, in the other germ of this question is when I was an undergraduate, there was a professor who had what he called a free speech board or window of his office, and any person was welcome to post whatever they wanted there. This was in the days before the internet, as long as they listed their name, and they also needed to say how long they wanted the idea up. But he wouldn't allow for anonymous posts. And again, so that's the root of my question: is what is FIRE's view regarding anonymous free speech?
Well, Robert, anonymous speech. Important, not important, protected, and not protected?
Important and protected, and for very good reason. A lot of folks are suspicious of anonymous speech, and there's a function to that. And I think that it's right that people be a little bit more suspicious because obviously you can't trace the source. But there are also places and times where anonymous speech is extremely appropriate and extremely important, and probably the most famous of those times was around the time of the American Revolution, where many of the pro-revolutionary tracts were published either anonymously or pseudonymously, that is under a false name, in order to get that message out, but avoid the British retaliation that would surely come. Obviously, Thomas Paine's Common Sense is probably the most famous of those pamphlets. It was originally printed anonymously, again for very good reason. It was not something the British would have appreciated. And there's another, also from the founding times, though not the Revolution. The Federalist Papers were written pseudonymously under the name Publius, even though they were written by three people, Madison, Hamilton, and Jay. And the reason they did that is because for another purpose, anonymous speech is to separate the identity of the speaker from the message they are trying to communicate. Forcing
people to engage with the ideas.
That's right. You force people to engage with the ideas instead of saying, well, you know what, Jay's my guy, so I'm just going to agree with what he says. I tend to agree with Hamilton, so he's probably right in, this particular, Federalist paper. Instead of doing that, they wanted to actually force people to engage the ideas. And so anonymous speech, those are two very obvious and important functions. I think to go to the caller's question, at Northern Kentucky University, what was at issue there was a satirical flyer that had been posted for a Welcome White Week that was satirizing a real flyer that was posted that said it was Welcome Black Week. I guess it was, Welcome Back activities aimed at African Americans on campus. So I guess somebody decided to make fun of that and put up a Welcome White Week flyer that looked almost identical, but had flipped those certain things. Often satire is another thing that happens anonymously, and the reason for that is that satire is one of the things that the authorities and the people being satirized hate most of all. I mean, there's very little that bites more than satire, and so it's important that people have the right to do that. As for the other thing he brought up, which was his professor's free speech wall, there's also a place for creating forums where you encourage people to say whatever they want, but they need to say it under their real name. And again, that's to, as opposed to force people to just simply engage the ideas. I think the idea is to say, you need to take, credit or blame, I guess, either way, responsibility for what's being said here, so that somebody knows who to confront and that you will be made to defend your ideas. So those are two sorts of different kinds of forums. I think there's good uses for both of them, and certainly a professor is free to create a forum on his door that would either be totally anonymous or, like you said, say anything, but you have to put your name. But when it comes to public universities and private universities that claim to have similar rights to the First Amendment, anonymous speech is something that they do need to have a place for. It may be frustrating. People may say things that are unpopular, and universities want to go after them and punish them. But frankly, I mean, that's precisely what the British wanted to do. That's simply not a good enough reason to prevent anonymous speech.
I really like that you brought up satire, because one of the biggest free speech stories in the past couple of days is that Kim Jong-un in North Korea has banned sarcasm. How you do that, I don't know. If there's going to be a country in the world that does it, it'd probably be North Korea.
Yeah, it makes it stick. It would be them. But I mean, exactly, because it is so biting and it is so effective, and it has the it also has the sort of subversive nature, and of course I doubt they care much for subversion in North Korea. It has that subversive nature that if you just quote it or you hear somebody saying, "Oh yeah, that Kim Jong-un guy is super great," it doesn't capture the tone, and yet how do you enforce that? You just said the guy was super great. Same thing with, satire like that Welcome White Week. It makes people say, well, is this, if I would object to this, why would I not object to this other thing? So it's a powerful tool, and, it doesn't surprise me that dictators would want to. I'd never heard of banning sarcasm before, but satire is really just a more sophisticated version of sarcasm.
Yeah. Yeah. Well, Robert, I appreciate you coming on the show to talk about your forthcoming book, Twisting Title IX, which is about the history and current abuses of Title IX. This podcast is hosted and produced by me, Nico Perrino, and recorded and edited by Aaron Reese and Chris Maltby. To learn more about So to Speak, you can follow us on Twitter at twitter.com/freespeechtalk, or like us on Facebook at facebook.com/so-to-speak-podcast. You can also email us feedback at so-to-speak@thefire.org, or call in a question like David did at 215-315-0100. If you've enjoyed the show, please consider rating us and posting a review at iTunes or wherever else you get your podcasts. Thanks for listening.